My name is John Morris. This is Kieran Purcell and Quinn Sperry. We're going to talk a little bit about divisiveness and how to address that issue. You can go a lot of directions with divisiveness, and there's a lot of material to cover there. Our focus is going to be on the ethical implications for the most part, although Kieran's definitely going to get into some practical approaches to various types of disputes we run into in associations. With that, we'll get moving. Where is the... we're going to work through this scenario. We initially had 4 or 5 scenarios, and then it just became too much. So this one really highlighted a number of issues, and we can talk about the implications of dealing with this. You have a minority group of board members that demands that the association lawyer sue the majority of the board for breach of fiduciary duty in the renewing of a management contract because they didn't go out to bid. How do you deal with that issue? And all sorts of problems are implicated when you have board members fighting it out with other board members. And the most important thing is, as we get into the ethical issues here, understanding who we represent. So we'll start there, but this is an overview. We'll go through who we represent. Then we're going to talk about the types of disputes you can run into in an HOA, generally categorizing those disputes so you can start thinking a little bit about what are the ethical implications in the type of dispute we're dealing with, who are the parties to the dispute, the role in the various disputes that the HOA lawyer plays. Then we'll talk about trying to do business while board members are fighting it out with each other or with the association. Some practical approaches to various types of disputes. Then we're going to talk about the Saturday Night Massacre. You know, this is a reference to Nixon, not some horror movie. The call from the president at 9 o'clock at night that says, if you don't do this, I'm going to fire you. And how do you deal with that? The next is the appointment of special counsel. I think Kieran's going to talk about that a little bit on, what happens when you give an opinion to the HOA and the one board member who doesn't like what you have to say hires their own attorney, and all of a sudden you're dealing with another lawyer opinion and addressing that issue and how to approach that issue. All right, let's start with who we represent. And I've attended the several other sessions that this is an important focus. I'm not going to dwell on this too long. The reason this is important is because when it comes to dealing with internal disputes, the ethical rules require a heightened level of action on our part, and it all stems from who our client is and who our client is not. Do we represent the HOA, the board, the manager, the board and the HOA, the owners, the board, the manager, and the HOA? If you've practiced HOA law for more than 5 minutes, you represent the association. The problem here really is these various constituents typically do not understand that. It always cracks me up when I show up to an HOA meeting. The owners will refer to me as their lawyer and, you're our lawyer, what does this mean, and so on and so on. And the moment that same owner is in a dispute with the HOA, I'm not their lawyer anymore, now I'm the board's lawyer. And because I happen to be sitting at the table with the board typically, now I'm on their side, and they're wrong both times, right? I'm not the board's lawyer, I'm not their lawyer, I'm the association lawyer. So it's really a question of perception, and that problem that we have with managers who think that we represent them, board members who think that we represent them in their capacity as board members and personally, and trying to overcome that. So, of course, we typically represent the association. If we're representing the HOA, sometimes we come into these disputes actually representing a board member or a manager or an owner. If we do, the ethical duties are a lot easier to deal with and a lot more clear. But we'll focus on what happens when we're representing the association. Whatever that association is, it doesn't really matter. The ethical rules apply to unincorporated associations the same as corporations. In Utah, where I'm from, it's almost always nonprofit corporations. I think that's the same around the country, although they have a little bit of different terminology. Anybody here ever deal with associations that are incorporated or organized other than nonprofits or just some unincorporated association? We deal with LLCs or odd entities. What do you deal with?
A for-profit corporation.
Really, for-profits?
Yeah.
You see that? Is that a typical thing or a one-off? Yeah, I've had a one-off LLC that was really weird, a one-off for-profit, but it's typically because somebody screwed up at the development phase and didn't do it right. And once again, we don't represent the board, we don't represent board members, we don't represent owners, we don't represent the manager. Now this gets us to the first and the most important ethical rule when you're dealing with internal disputes. It's going to be 1.13, the organization is the client. Not all, 1.13 has a lot going on. Some other ethical sessions have gone through some of those terms. Our focus will be on a couple of sections and also the comment, which is really interesting. I have to say I learned something in preparing this, but we'll go through that in a second. The 1.13a makes it clear a lawyer employed or retained by an organization represents the organization. Nothing new there. Acting through its duly authorized constituents. A couple of issues there. Who are the constituents? What does duly authorized mean? These are things that we need to pay attention to generally. Let's talk about some good practices. These are lessons learned in doing HOA law for 15 years exclusively. This is a provision out of my engagement letter. Very clearly saying it is understood that our firm is being retained to provide services to an association, a Utah nonprofit corporation, or an association of unit owners. The next part is, I think, important. This is something I haven't seen too frequently in engagement letters, but if the association's corporate status should change, such as through incorporation or by the dissolution of its corporate status, this agreement shall continue to be binding upon the successor entity, association, or organization. How many people here have had their HOA clients fail to return the 2x2 card, their corporation is dissolved, and all of a sudden, 3 years in, you find out they haven't been incorporated for a year. I liked that second sentence because I don't want to mess around with that. Who do I represent if my engagement letter is exclusively with the corporation and the corporation's been dissolved for a year? If there's ever a question about that, I don't want that problem. So my engagement letter addresses that issue. Next paragraph in my engagement letter is probably just as important. The brackets are, we insert whatever it is, Board of Trustees, Board of Directors, Management Committee. You never know exactly what the name is going to be in the governing documents. But this paragraph, it's important to note that we are not being retained to represent any particular member of your board. The board is a body distinct from the association, the owners, any particular owner, or any manager. We represent the association. Now, the next sentence I think is also important because it helps explain, even though we don't represent those people, we constantly or frequently address problems that center around various types of rights. Naturally, our representation of the association can and sometimes will involve offering legal advice related to matters of particular concern to an owner, the owners, a particular board member, the board as a body, or the manager, all as may be appropriate and necessary for the proper operation of the association, and as may be requested by the board to carry out the purposes of the association. So offering some explanation of the reason that we might be giving advice about various constituents and issues, even though we don't represent them. So first thing is, who are the constituents? The ABA, and when I'm looking at 1.3, I'm talking about the model rule, and when I'm done, Quinn will come up and talk about the various state iterations to that and changes, so we'll cover those deviations, but most states follow the model rule, so we're going with that. Luckily, the model rule basically tells us who the constituents are. If you look in F, in dealing with an organization's directors, officers, employees, members, shareholders, or other constituents. So we know at least those people are the constituents as the rule is drafted. The next issue is the, who's duly authorized. This gets us to another practice pointer. What does duly authorized mean? And there are various sources of authority for a person on a board or in an association to call us and say, hey, you're the lawyer, I want you to do X. One is there can be a board decision. That may be reflected in minutes. How many boards do you guys deal with that do make decisions without meetings? I'm sure that never, or without minutes, I'm sure that never happens. But for me, it's all the time. But those decisions can be reflected in emails or other sorts of decision-making processes, which are decisions of the board, although, we constantly have to advise them on another practice pointer, trying to get them to ratify decisions they make outside of meetings at the next meeting and get it into the minutes to help protect those decisions. But nonetheless, a board decision is one way to get authority. Another way you can get authority is through the inherent authority of the officers. I've had associations before where this has become a hot topic, where board members are in conflict over using the lawyer or not, and we had to do a deep dive on this. The treasurer certainly has inherent authority to seek legal advice regarding the functions of the treasurer. So, even contrary to the direction or instruction of a board, certain officers have the right to deep dive, to get legal counsel to help what they're doing. Which is, you think that would never happen, right? Because if you're in conflict with the board, you would just remove the officer and then replace him with someone else. But of course, that doesn't happen. It had to get really difficult. So anyway, there can be inherent authority. The other is a term, implementing authority. I just use that generally. Board authorizes manager to deal with owner who is, making complaints about another owner. Manager calls lawyer and says, all right, I need some help with this. And this is an officer or an agent implementing some other decision of the board and then getting legal advice based on that implementing authority. Usually it's more direct, but these are various sources of authority. Of course, the interesting question is, and, we used to deal with this a lot early in our practice. We solve the problem now, but board member calls, says, Morris, I need you to look at section 4 of our bylaws and see what you think that says, and send me an email and about the parameters of this. I do all that, and I send it off. I send my bill, and then I get a call from the president, a month and a half later that says, why did you do that? So, well, Fred called me and said he needed that done. Well, Fred's one board member. He's not our board. Our board didn't make that decision. We're not, we didn't know Fred was going to call you, and we're not very happy about this bill. So how do we help avoid that issue? Protecting yourself, another practice pointer. Get it in your engagement letter. Who can direct you? get a resolution when you're hired that identifies who can direct you. And sometimes the most important way of protecting yourself in those situations is board member calls. You're not sure if board member has the authority to be engaging your office. You send an email back to the entire board and say, thanks, Fred. You CC everybody else. I'll go ahead and take a look at these bylaws, and I'll let you know what's going on. Email is the lawyer's best friend, right? I mean, it's just such a great way of documenting what's going on and who's instructing us. And, you get that email out, and if the board doesn't raise a ruckus, everything's good. This is another paragraph out of our engagement letter. Unless otherwise indicated in writing to the firm, each member of the board, present and future members, and if a property manager is retained by the association, the property manager, are each designated as spokespersons for you, and each shall have independent authority to communicate with and instruct the firm and its attorneys on what action we are to take and seek legal counsel from us for the association without further confirmation or consultation from any other spokesperson or any of your other officers, directors, or managers. You agree to notify us in writing if any changes are made by you related to the persons who have authority to direct us and request services and counsel from us. So this is an attempt to protect us if that ever goes south, although to protect the relationship you need to know sometimes we write off fees when that happens. That's just the way it goes, but this helps. The other thing we do is when we get an engagement letter with a new association, we have a resolution, and in the resolution, we state this again, basically, in without the context of a longer engagement letter, and about 4 out of 5 associations, everything just goes through. They're fine with it. Maybe 1 out of 5, maybe 1 out of 10. They see that, they seize on it, they understand the issue, and they actually have us make modifications and direct us as to who the board members are or manager that can instruct us, which helps get us on the same page. So let's go back to Rule 1.13F. Let's think back to our hypothetical. We have a minority of board members who have called the lawyer and said, you need to sue our majority board members on behalf of the association because they signed a management agreement without getting bids. They have breached their fiduciary duty. So the first thing, all sorts of issues, should be popping up in our heads right now, various ethical rules when we get that call. If we look at F, this is the core of the problem in dealing with internal disputes. In dealing with an organization's directors, officers, employees, members, shareholders, or other constituents, a lawyer shall explain the identity of the client when the lawyer knows or reasonably should know that the organization's interests are adverse to those of the constituents with whom the lawyer is dealing. Now, so the moment, and it's really interesting when you start thinking about hypotheticals and contexts that can trigger this, and it really is subtle. We have to be paying attention to this issue. It can be very simple discussions. Folks, we're in a meeting with the board. We're talking a boundary line issue. We've got a common area problem. Maybe we found a couple fences that are 3 or 4 feet into the common area, and board member Y says, I'm along that property line. I don't think there's anything wrong with where those fences are. Have we just triggered a situation where now we need to explain to board member Y, hey, you need to understand, I'm not your lawyer. I represent the association. When in your personal assertion of where your particular fence is, you might need counsel on that, and so on and so on. It can be very subtle, very simple situations, and in those situations, we have a pretty solid ethical obligation to make disclosures. And remember, this all comes back to, why do we have this? Because those people think we represent them. that is the problem, right? If I were just walking through the HOA and the neighbor, a property owner comes up, a neighboring property owner, and says, hey, you know, I think there's a boundary line issue over here, and let me tell you about this. This is someone outside the HOA. Do I have any obligation to give them any ethical warnings? No. I'm happy to listen to whatever they want to tell me that might help my client and pass that along to my client, because they don't think I'm their lawyer. That's why we have this heightened ethical obligation to all these constituents, because they either don't get it, they don't know if we're their lawyer or not, or half the time they think we are. Now, the comment to the ABA rule really goes a lot deeper than this. The first comment is the first part of the comment, there are times when an organization's interests may become adverse to those of one or more of its constituents. In such circumstances, the lawyer should advise any constituent whose interest the lawyer finds adverse to that of the organization of the conflict or potential conflict of interest that the lawyer cannot, that the lawyer cannot represent such constituent, and that the person may wish to obtain independent counsel. This next sentence is the real kicker. Care must be taken to assure that the individual understands that when there is such adversity of interest, the lawyer for the organization cannot provide legal representation for that constituent individual, and that discussions between the lawyer for the organization and the individual may not be privileged. So not only do I have to disclose, I need to make sure that they understand that. And I see that as a significantly heightened burden, right? Now I need to make sure they understand an important concept. The next note is whether such a warning should be given by the lawyer for the organization to any constituent individual may turn on the facts of each case. Yeah, duh. Like, that's really helpful for us, right? So the short version is we have to figure this out, and then we are obligated to make the disclosures. So if you parse through 1.13F and the comment, this is sort of where I end up as the safe place to be. What do I need to do when board member Y says, you know, I think my fence is in the right place and it's along that fence line, and you know, and I'm sitting there thinking, I think your fence is 3 feet into the common area. What do I need to do with board member Y? One, I need to advise that board member that there's a potential conflict of interest or an actual conflict of interest. Number two, I need to advise that board member that I don't represent them and I cannot represent them. Number three, I need to advise them that they may wish to obtain independent representation. Number four, I need to take sufficient care in talking to that person that assures that the individual understands that I can't represent them. And I need to take sufficient care in talking to that person that assures that the individual understands that when they talk to me, that is not a privileged communication regarding their issue, right? No privilege there. So this is 1.13F when you have these internal disputes. This can happen all the time. Now, once again, why do we have these concerns? Because these people think we represent them. They think that we are their lawyers, and we're not. So we have to be extra diligent in informing them. Practice pointer, best way to protect yourself on this, have the conversation, whatever, and then send the email, right? That says these things, and by the way, CC the board. Because we have a duty to inform the association too as to things relevant to our representation. So we send the email, we confirm these things, get it in writing. Now, before we get into the variations, which Quinn will cover, one last let's see here. Oh, we'll save that to the end. So right now we will move into what are the state variations on 1.13 and where do we go from there?
Thanks, John. Just as John said, he focused on the ABA Model Rule 1.13. I'm going to go through and talk about some of the state variations. As I do that, I'm going to give you a little bit of history. Those of you who are looking at this slide, it has nothing to do with the legal rules or anything. This is something, I'm going to give you a little historical context of the rules, and I know some people, they hear history or historical context and their eyes just gloss over. So this is a slide courtesy of Google that you can look at and just start to see what were some things that people Googled for the cost of a certain item or goods, and this was the popular one by state, so you can just peruse that as I give you a little historical context. Really, we look back at the variations in the ABA rules. They stem from the early 2000s. We're looking in the time in October of 2001. This is when Enron, the collapse of Enron, hit the news and was publicized, and it was soon followed by other corporate scandals, including WorldCom, Tyco, and Held South. It was then in the spring of 2002 that the American Bar Association Presidential Task Force on Corporate Responsibility was created. And the purpose of that was to present policy recommendations focusing on the responsibility and the value of the legal profession in impacting corporate governance and to promote corporate responsibility. So this task force focused on two of the main ethical rules, which was 1.6 and 1.13. And this task force proposed some changes to these rules, which were then accepted in 2003 by the ABA House of Delegates. So that's what helps us get to the variations. In the written materials that accompany the presentation, there's a 2017 ABA study that goes through some of the state variations of the model rule. Since that was done just a couple of years ago, there have been some changes. So I'm going to go through some of the updates on that, so don't rely just on those materials that the ABA came out with a couple of years ago. 21 states now follow the ABA model rule, which is what John just covered. And for purposes of the recording, I'll read through those, even though I know you can see them. Arizona, Arkansas, Colorado, Connecticut, Georgia, Idaho, Illinois, Indiana, Iowa, Kentucky, Louisiana, Massachusetts, Nebraska, New Hampshire, New Mexico, Oklahoma, Oregon, Rhode Island, South Carolina, South Dakota, and Wyoming. If you're in one of those states, you follow exactly what John was just talking about in going through those model rules. There are 10 states and also the District of Columbia that follow the old former model rule, which does change slightly, and I'll have that on the next slide. So these states are Alabama, Delaware, Florida, Kansas, Mississippi, Missouri, Montana, Pennsylvania, Virginia, West Virginia, and then, of course, the District of Columbia. So what really changed in all that? Well, subsection A, if you're in the current model rule or the former model rule, it's the same. Really what we're looking at in what John covered was subsection F in the old rule. That was subsection D. And it's very similar. What they changed was just what I highlighted there. So in the current model rule where it talks about if the lawyer knows or reasonably knows there may be some adverse interests, then the lawyer has to advise them as to the potential conflict or who his client is. In the old model rule, it's when it is apparent. So a little bit different standard there of what you're looking at. In the District of Columbia, instead of subsection D, they have it as subsection C, and they replace it has when it is apparent, but then later on where it talks about interests are adverse, it talks about that the interest may be adverse. So that you've got to look at that little variation if you're in the District of Columbia. Then there's some other states that follow the model rule, but also have some differences throughout the rest of their rule. So even though we were for purposes of today, we're talking about Model Rule 113A and 113F. If you're in these states, you have to know they didn't just adopt the Model Rule in total. They made some additional changes. So in North Carolina and Vermont, the subsections A and F are the same, but they have some additional changes throughout the rule. In Alaska, they add an additional subsection H, which then goes on to define the word constituents that is used in the other parts of the model rule. So that helps you better understand who it is that falls within the identity of your client. In the states of Hawaii, Utah, and Washington, they add a subsection that brings in attorneys if you're representing a governmental entity. Then they are stating that for purposes of this rule, that governmental entity becomes the corporation. So that governmental entity would be your client for purposes of these ethical rules. Maryland and Michigan, they adopt subsection A verbatim, but then the model rule F, they've adopted that as subsection D. So other than that, it's the same as the model rule with maybe some additional changes in those other subsections. Maine, Minnesota, and Tennessee, again, they've adopted subsection A, and then they have subsection E rather than F that follows the model rule. As you get into North Dakota, they're following the model rule except for some of the language that is highlighted there. This is, so again, it's instead of knows or reasonably should know, this is that they reasonably believe that the organization's interests are or are likely to become adverse to those of the constituents with whom the lawyer is dealing. So again, you've got to look at the wording of your particular state to see, well, when do I have to disclose some of these things? What's the standard for me? Wisconsin, they have the model rule A, but then they go back and adopt some of the language in the former model rule of when it is apparent when they talk about the subsection F that John had talked about, and they incorporate that as D. In Nevada, they adopt subsection A verbatim, but when it gets to F, they have their own additional language that they put in there. And so if you're in Nevada, you can read through that and start to see, okay, how does that impact who it is that I have to advise on this? I mean, when do I know or reasonably know that there's going to be this adverse interest? And then they also give a reference to an additional section where it's talking about the multiple representation of the various constituents. In California, this is one, hopefully if you're practicing in California, you're aware that your rules changed just a few months ago. They became effective November 1st of 2018. And in substance, they do follow the model rules, but the form's a little bit different. Of course, they had to change that. And I know Kieran, that's where he's from in California. And they just have to be a little unique, even though the substance of it is there. But they couldn't just take the language of the model rule. They had to tweak it a little bit. So that's your language, even though the substance of it is essentially the same as the model rule. So okay, we've got New Jersey. Again, this is one where in subsection A, they did not just adopt the model language. They made it much longer, and you can see that there. The language that I thought was interesting is they bring in the second sentence that for purposes of some of the other rules of professional conduct, that you're not just representing the organization, but for purposes of that, you are also representing the members of a litigation control group if one's been set up. So you definitely have to look at that because, again, we're not, as you look at who are the constituents that John covered, you're not representing these individual board members, but in New Jersey, they're bringing in saying, well, if there's a little litigation control group, they are becoming a part of that client or the entity that you're representing for purposes of that, so you need to look at it. And then also the second half of the second section we've been discussing today, F, they incorporate as D. A lawyer shall explain the identity of the client when the lawyer believes that such explanation is necessary to avoid misunderstanding on their part. And to reiterate that last slide that John covered, well, how do we know when that's necessary? It's case by case. Obviously, I guess a good practice pointer, when in doubt, go through and make sure it's clear that everybody understands that, so that to avoid any of that misunderstanding. In New York, they kind of do a hybrid or take the model rule A and F and combine it into just a subsection A, which is a little interesting. They have no separate subsection F that the model rule has, so they've essentially taken some of the concepts of those two subsections and combined it into one. In Ohio, again, they've modified the subsection A, and then they follow the former model rule D, which again, that language is when it's apparent that the interest may be adverse. So that's what you have for A. And then the last state variation that we have is Texas. Texas, their rules, their numbering is a little bit different. Rather than 1.13, theirs is 1.12, and then this is the changes that you have that they've put into place in their rules. So again, the majority of the states are following either verbatim or definitely in the concept of the model rule, but some of those states have modified them to a degree. So always a good idea to be looking at your own states, and if you practice in multiple states, keep that in mind that it could vary as far as the disclosures that you have to give to your organizational clients and their constituents. So moving on to the next part, that'll be Kieran.
Thanks, Quinn. In doing my research for this part of the presentation, I came across this quote from Potter Stewart. It said, "Ethics is knowing the difference between what you have a right to do and what is right to do." And I found that really powerful, and it's amazing how many times it came back into play as I was going through the scenarios and some of the issues that arise from them. As John mentioned on the onset of the presentation, largely our portion here from the remainder is going to talk about the ABA model rules, but the written material that is included on the app has some highlighting of the different states, and so you can refer to that afterwards if you like. By the way, I had to explain to my 9-year-old daughter that Potter Stewart was no relation to Harry Potter, so thought that was kind of funny. Okay, this is by no means an all-encompassing list of the possible disputes that can arise in community associations, but it's a list of some of the more common disputes that you might come across. And we're going to break them down one by one. Okay, the first issue that can come up, an owner-to-owner dispute, initially might seem like it's the easiest type of dispute to deal with. You can look at it and say, well, gosh, it's Smith versus Jones. The HOA is really not a part of this. We're just going to, in the immortal words of Nancy Reagan, say no, and we're going to stay out of this. However, your experience may be similar to mine, which is that many homeowners come to think of the board and the council as mom and dad, or as the landlord. You're ultimately the arbiter of any kind of dispute amongst the parties, and that you really can't bow out of it, because they'll come to sometimes extraordinary lengths to try to find some point in the CC&Rs or the rules that it's been in violation in order to try to bring you back in. If you're fortunate, like we are in Southern California, there is a low or no cost dispute resolution service that's provided through funding. When you file a civil lawsuit, they take a little piece of the filing fee, and it funds community mediation programs in the various parts of Southern California. So that's been a pretty successful means for us to say, well, this is really not an issue here. There's not an apparent violation of the CC&Rs we can see. However, this service is available. It's free. We urge you to take care of it. And it also gives you some cover to say, well, hey, we gave you the tools to resolve the dispute on your own. You chose not to participate in that, so we're going to back out. So if you have that option available in your jurisdiction, you might consider trying it. We've had some good success with that. Another dispute that comes up is when you have a board member versus an owner dispute. This initially it takes some analysis, because you have to look at it and say, well, is it really owner versus a board member as a board member, in which case you say, well, it's really owner versus association, and we're going to talk about that dispute in a little bit. But if it just is an owner versus another owner, and that second owner just happens to be a member of the board, that's the issue we're going to talk about here. As John mentioned earlier in his remarks, that one of the challenges often can be explaining to your board member that you are not their lawyer. We spend a lot of time talking to particularly board presidents and others, and after a few years, they come to think of you as their lawyer when, of course, we aren't. And at this point, some community association lawyers just say, well, gosh, there's a conflict of interest here. I can't represent the association and you as an individual, and they just back out. But is it really an ethical violation to represent both the HOA and an individual? Well, as John pointed out to you, that it really is going to depend. And so I think that's every client of ours' favorite word, maybe, right? They love hearing that from their attorney. Well, it depends. Well, it depends a little bit upon what jurisdiction you're in. Under the model rules, 1.13a, as John talked about, provides the client is the association and the attorney takes their direction from the association's board of directors. So pretty straightforward. However, you might be surprised that 1.13g comes into play, and it says an attorney representing an association may represent its individual directors, officers, and employees if there's no direct adversity or significant risk the attorney's representation will be materially limited, and that it requires written consent, informed written consent from both parties of the dual representation. So think about where you are in the dispute. Sometimes it's very early on in the stages of this matter. You really don't know that much. You know the straw that broke the camel's back because that's what got them in the room, but you don't know about any of the other straws that are involved. So you're being asked to make a decision about, well, no direct adversity. Well, there may not be on this day one, but that doesn't mean there won't be. And so that can be a challenging situation to make. And then the issue about whether it may limit your representation of either party, that's challenging for you to make. So getting back to Potter's theory, just because you can do something, maybe you shouldn't. So this is something you want to not go into lightly.
Kieran,
how many minutes does it take to turn on a microphone?
sorry.
The answer is 3.
Addressing that point
Sure.
Head on with representing board members and sometimes even owners, we will get requests from a board member, okay, can you represent me personally in this, or even owners sometimes in a owner v. owner dispute, can you represent me, the association's out of this, and help me with that? As a policy, we say no. If we represent the association, it's no. And the only time we make that exception under that rule is lawsuit against the association, names a few board members. If we happen to be appointed by the insurance company, if there's insurance, if we go through that, in those situations, we will jointly represent the HOA and board members. But any other time, we just say no.
Thanks, John. Okay, another issue arises in association versus owner disputes. Much like the board members are sometimes surprised to find out you're not their lawyer. How many times have you had an owner come up to you and say, I pay my assessments. My assessments pay your fees, so you're my lawyer. You have to do this for me. And of course, the answer is no, but there's sometimes some education involved there. And it's also, it's kind of interesting because we work so closely with the association and the board of directors. Initially, when you're in a dispute with an owner, you may start off thinking, well, gosh, the association is right, the owner's wrong, because you kind of get in that mentality. But it's important for you to take a step back and look, because you know the facts sometimes from the prism of the board member or the manager, but you don't necessarily know all the facts. And so that sometimes what initially presents itself as kind of a cut and dried, well, gosh, the HOA is right and they're wrong, it doesn't turn out to be the same. So as a young lawyer, I made that mistake, and I learned that sometimes you've got to hold a judgment till all the facts are in. And another situation you want to consider is what's the outcome you want. Sometimes the board wants a quick decision, but oftentimes the expedient decision isn't really the best decision. You may end up with a decision that has long-term unintended consequences. So that's part of the counselor role as an association, community association attorney, is to explain to them that we're a little bit different. The board members live in their communities generally. They walk their dogs, they get the mail. They get direct feedback from their constituents on a day-to-day basis. And unlike other corporate clients, that they're one recall petition and vote away from being out of office. So you have to explain to them there can be some consequences to their actions, and that sometimes making a quick decision isn't always going to be the right decision. We, from a good practices tip here too, and I'm sure most of you probably already do this, but making sure that when these disputes arise, that you're putting your, advising your client to put their insurance carrier on notice when there's facts and circumstances that could give rise to a claim. We had an issue in one of our rural clients that had some hiking trails, and in the open board meeting, during the homeowner forum portion of it, an owner got up and just said, hey, has the board ever considered trying to provide handicap access to the hiking trails? And the board said, well, gosh, based on the terrain and so forth, it didn't seem possible, so we haven't really looked into it. And they didn't think anything of it. Well, a couple of months later, of course, they get the Department of Fair Employment and Housing letter to them explaining that there was a claim being made against the association because they'd failed to provide a reasonable accommodation for a disabled homeowner. It turns out the woman who asked the question's husband was in a wheelchair, so we denied a reasonable accommodation request. Well, no one ever even thought of it in that context. So HOA tenders to its insurance carrier, they conduct an investigation, and they say, well, gosh, you knew about this 3 months ago. You didn't tell us to us. And of course, the insurance company always looks at it from the standpoint of, they have this crystal ball, and if only they had known, they could have resolved all these problems and it wouldn't have happened, so they denied coverage. So just a good example of why you want to sometimes overcome the resistance from the board and the manager. Sometimes they're reluctant to contact the carrier. They're worried about their loss history. They're worried about any kind of change that might affect their premiums. But it really is something that you, as an attorney, you can't go wrong with recommending that they contact the carrier and put them on notice because ultimately it may affect coverage later on down the road. Okay, I know you've been eager to dive back into the ethical rules on a Saturday morning, so let's do it. 1.2 of the model rules, pretty straightforward stuff. An attorney shall abide by the client's decision regarding the objectives of the representation and shall reasonably consult with the client as to how they're going to achieve those objectives. Okay, pretty straightforward. And then 1.2D talks about discussing legal consequences. But as we started to talk about, we have a different client base, and legal consequences certainly are important, but the practical and the political consequences sometimes can be equally important. So don't forget to consider those when you're helping come up with options for your client in making a decision. So now if you have an owner versus a HOA dispute, it's not uncommon the owner's attorney may want to come to the meeting or the violation hearing. And so whether they're allowed to do that is going to depend a little bit upon your jurisdiction. Some associations, CC&Rs, although in our experience very few, thankfully, have almost constitutional due process, right, to meet and confront your accusers and subpoena records and bring attorneys to pretty much anything they want to do. Fortunately, we don't see that a lot. There's actually good case law in California, and this is a case, SB Liberty versus Isla Verde Association, that I'd urge you to read. It's in the written materials if you haven't seen it before. In this case, there was an LLC that owned a unit in an association, and the attorney for the LLC wanted to attend the board meetings. The court ultimately concluded that he was not entitled to attend because he was not an owner, as that term was defined in the governing documents, and he was neither a manager nor a member of the LLC that owned the unit. He did have a proxy, but the proxy was very narrow in scope and didn't give him the right to either attend the meetings or vote. And so the court sided with the association and said, no, you don't have a right to attend the meeting. And the holding of the case actually is really very strongly in our favor. It says a meeting of an association's board of directors is a private meeting. It's held solely to discuss the business of the corporation. And while members of the association are entitled to attend, non-members do not have a right to attend unless the board allows it. So essentially it said the board has the power to control the conduct of the meeting and who may attend the meeting. So it's a very, very good case from our standpoint.
Can I jump in there real quick?
Sure.
So Utah has what we call our open meeting statute for HOAs and board meetings, and explicitly allows either the attorney or a representative of the owner to attend board meetings. So you might want to take a close look at your acts to make sure there's not something different than this.
Yeah, it definitely will change jurisdiction to jurisdiction. And don't forget to look at your governing documents too. Okay, another variation in this is, what if the owner in the dispute with the association is a board member? So that adds to some of the complexity of the situation. Recall ABA Rule 4.2, it says that it prohibits an attorney from communicating directly or indirectly with a party that they know is represented by counsel without either the counsel being present or without the consent of that counsel. And so that if the owner is there by themselves without their attorney, you're in a position where you need to make sure you don't engage with them. And it's hard to do sometimes because sometimes you don't find out until midway through the owner's question that they're actually represented by counsel. But if you do find, if the dispute is within a board member is represented by counsel, you want to create a litigation committee. Most of us generally have probably been doing that for a while, creating a board resolution which allows you to preserve the attorney-client privilege between yourself and the association through a subset of non-party board members. And so you can create a resolution that identifies who those board members are, what their duties are, and so forth. Sure.
Interesting. So we've used that committee process many times. It was interesting at another ethical presentation here, some discussion of that committee process. And apparently it's improper to form that committee just to exclude a board member from certain discussions, right? So you can't just, if you're adverse to a board member in the sense of just opinion, you can't just create a subcommittee, move all delegation of those issues to the subcommittee to just get the board member out of the issue. So now we're going to walk this careful balance between, do we really have a legitimate dispute with the board member such that it allows the formation of the subcommittee to address that? You know, clearly if there's a lawsuit or something like that, you know you're clear. But the pre-litigation discussions, not so clear that you can form that subcommittee and just exclude the board member from those conversations. Interesting issue.
Thanks, John. And here's an example of what one of those resolutions might look at. I know it might be a little challenging to read from in the back of the room, but it's also available in the written materials if you want to take a look at it. Okay, association versus third-party disputes. Certainly a pretty common situation. This is a situation, too, where even if you've represented the association for a long time and you think you have a pretty good feel for the history, you may not know all the issues that gave rise to why they ended up in this situation. I had a circumstance a couple of years ago. We represented a master plan community, and we took an owner to mediation for one of those, kind of garden variety, like landscaping violations, parking violations, all the really glamorous stuff we get to deal with on a day-to-day basis. And we're about an hour and a half into the mediation. Things are going pretty well. We're on like the second or third version of the settlement agreement. We thought we had it all resolved. The mediator comes in. I think he's going to give us the copy of the agreement to sign. And he's like, hey, the client wants to know why the lawsuit's not included in the settlement agreement. And myself and the board members all look at it like, what lawsuit are you talking about? Well, it's a master plan community, and the owner happened to live in a sub-association as well. We didn't represent the sub-association. None of the board members for the master were on the sub, but the same management company represented both master and sub, and they had commingled their billing statements for convenience purposes, and so that they'd sent out notices about the delinquency. It wasn't for a delinquency to our client, but to the other client. And that not only had they sent out the lien, they'd foreclosed on the lien, they were actually in the post-foreclosure redemption period, so it was pretty far down the road. And so what turned out to be, we thought it was going to be a pretty easy afternoon, turned out to be a pretty long day. Ultimately, we got to resolve the thing, but it's one of those, it's a good example of that you don't always know all the facts going into it, and that there's going to be some challenges you got to be prepared for. Okay, one common third-party dispute is good to talk about because it comes up a lot, and it's the issue of, in many community management agreements, the HOA is obligated to defend, indemnify, and hold harmless the community manager. Is that common for you folks as well? Well, so you might find yourself in a situation where a third-party contractor is suing the HOA and the manager. And so that can put you in a bind, as John referred to before. So 1.13 of the rules is important, but we also want to talk about 1.7. So 1.13, pretty straightforward. An attorney representing an organization may also represent directors, officers, employees, blah, 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 and other constituents. So we talked about that a little bit, but it says subject to the provisions of 1.7. So let's look at 1.7 and see what it tells us about this. 1.7 says a lawyer shall not represent a client if the representation involves concurrent conflict of interest. And then it goes on to define what that is. So the first part, pretty easy, directly adverse clients. You get that. That's even we can figure that out, right? The second one's a little harder, though. It says there is a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client. Well, gosh, that's a little bit harder, right? Day one, we get the complaint in. Our client's pure as a driven snow, we think, but do you really know? Manager and board, oftentimes, while their interests are aligned initially, they may get divergent as you go down the road. So this is a challenging decision to make, especially when you didn't necessarily have all the facts. So if you do make that, sir.
To bring this down to the practicality into the driven snow, the most common kind of manager is indemnified claim we see in the Northeast is a slip and fall case for failure to clear snow. They sue the contractor, they sue the manager, and the managers
Sure.
have these indemnification clauses. And the association is liable under a theory of landlord's liability. Usually, there's no finger pointing, but there can be. In that case, is that a situation that generally you would think would be create sufficient possibility of adverse interest that you ought to decline at the outset and say the association is going to have to hire a separate counsel for the manager, or would you go forward with a caveat?
He's not a paid shill in the audience, but he's asking a good question that really gets us right into where we're going here. So if you bear with me, I think we're going to answer that question for you. So you're in the situation this gentleman is talking about, and one of the things you can do is get a conflict waiver. And so when I was a young lawyer starting out, a conflict waiver is like, well, I represent the HOA. We're aware that there may be a potential conflict that may arise between the HOA and the community manager. But if that conflict arises, then both parties agree to waive that conflict. Kind of something very similar like that. And while that's okay, it doesn't really handle the situation that this gentleman talks to. Is well, what about as you get further in the investigation, you find out, well, gosh, the manager did or did not do something they might have done, or they might have done that would have resolved the situation, and as a result, now your interests are divergent. So if you just have a simple conflict waiver, you may end up having to withdraw from representation of either party. So that's a disadvantage to both the clients, because now they've got to go out and get new counsel. It's also a disadvantage to you. You may have lost some business there. So consider how you write your conflict waiver agreement. And actually, John gave me some great language, which is included in the next slide here. And basically, it says that if a conflict arises during the course of the dual representation and the attorney is obligated to withdraw from representing the manager, they still retain the right to represent the original client, the association. So consider putting that into your conflict waiver, so it might help you in that situation. The other thing to think about, too, is that while the HOA and Mr. Smith or Mrs. Jones, the manager, may be the parties in the lawsuit, in reality, they may be actually suing the management company as well. And so who's signing that waiver, bless you, on behalf of the other party? What may not be the manager. It may have to be somebody who is a senior person, the president, the CEO, someone who has authority to sign on behalf of the community manager. So think about not only what the agreement says, but think about who's signing it.
One more quick point here, Kieran. As to your question, too, a good strategic decision, when you start getting out of the D&O range into the pure liability insurance coverage, which your slip and falls fall under, pretty frequently there's a defense obligation and indemnity also. So the insurance company will be interested in appointing an attorney. This would be the time to say no thanks. As the HOA's counsel, we're not a slip and fall firm for the most part, and maybe let the insurance company appoint whoever they want, and then you don't have to deal with those issues, right? You remain neutral. You can focus on the HOA's representation and watch that proceed and not have to worry about the conflict issues. Even if you had a chance, right? Most of the time the insurance company will choose the attorney for the defense anyway.
As a good Southern Californian, I'm going to defer to my colleague from Utah on the concept of snow removal. So this is the agreement we talked about a moment ago. I actually stole this from John, or sorry, borrowed, sampled, whatever the kids are calling it these days. But not a perfect agreement, but it's something that covers the issues he just talked about, and it's available in your written materials if you're sitting further back and can't really see it too well. Board member versus board member disputes. I told you we'd get back to it, and of course we will. And it seemed like only fitting to include a picture of Hatfield and McCoy, because they're the most common name that maybe you think of when you have disputes. So when this situation arises, one of the first things you're going to look at, much like with any dispute, is like, what's the dispute really about? Is it Hatfield and McCoy don't like each other because they're neighbors and the dispute has nothing to do with them being board members? In that case, you may be able to try to get out of it, not be involved in there. However, if you're not successful in doing that, one thing you might want to start talking to them about is that most states have some sort of fiduciary duty obligation for board members, and start talking about what that means. Oftentimes it means that they have an obligation to the association. In some communities, it actually mean, or jurisdictions, they actually have an obligation to the owners as well. So you want to talk to them about what the ramifications of that are and how that's going to be impacted by their dispute. Most jurisdictions also have some manner of a business judgment rule, and it also has some criteria that the board members are obligated to perform under, acting in good faith, due diligence, acting in the best interest of the corporation. Well, are Hatfield and McCoy fighting about something just because they don't like each other, or are they really in a situation where they both think they've got a better way of doing things and it's in the best interest of the corporation? So think about those two issues as possible means that you might help to try and start to diffuse those situations. As we talked about in the outline, what you're really trying to avoid is the Saturday night massacre, as some practitioners call it. And this is a little more background to what John talked about before. So 1972, Watergate scandal is in full swing. There is a special counsel appointed to investigate. The president doesn't like what he's doing. Does this sound familiar to anybody? So President Nixon decides he's going to order his attorney general to fire the special counsel. The attorney general, Attorney General, Elliot Richardson, took me a minute to find it, is ordered to fire Archibald Cox, the special counsel. He says no, and he resigns. It doesn't end there, though. Then Nixon doesn't back down. He goes down to the next person, the deputy attorney general, orders him to fire the, and I won't even try to pronounce Ruckelshaus. So he orders him to fire Cox. Ruckelshaus says no. He resigns as well. Next person in the line, an individual who's a solicitor general, a guy named Robert Bork, who becomes famous a few years later for other reasons. Ultimately, he thinks about resigning, but then he follows Nixon's orders and fires Cox. So there's a huge outcry, political ramifications, and that ultimately a new special counsel is appointed, and the courts ultimately decide that the termination of the special counsel was illegal. So that's a little background of where that term comes from, and you can see why this might have some implications in a community association. So let's go back to that scenario John laid out at the beginning of this. You got a minority group of board members, and they're demanding you as the association's attorney sue the board majority. They want to enjoin the performance of a management contract that was recently renewed. The allegation is that the board majority breached its fiduciary duty because it did not go out to bid. It just renewed the existing management contract. So let's look at some of the ethical issues that arise. So 1.13, we talked about this a couple different times. Does the minority group of board members have the ability to order you to do anything? Well, no, they're not the governing body of the association, so they have no right to take any action. Of course, when you just tell them that, that's probably not going to make the situation go away. So what are some things that you can do to try to help diffuse the situation a little bit? Well, we talked about, much like with Hatfield McCoy, business judgment rule, fiduciary duty. Go over those issues and what the implications are to them. That if you are found to be in violation of your fiduciary duty, then you may not be covered by the directors and officers insurance for the association. You may have personal liability. Well, sometimes it gets people to be less interested in that because they're worried about their own personal well-being. You might also talk about what are the consequences of this action, and is it really going to get them where they want to go? So if they file suit against the association and they're seeking to end the management contract, they're paying one set of attorney's fees, they lose contractually, they may end up paying a second set of attorney's fees, they may end up paying consequential damages to the management company. But even if they win, do they really win? So now they assume they succeed, they've terminated the management contract, now the HOA is without a manager, they have to go out to bid, they have to interview people, so there's a period of time in which the community has no management at all. Is that really in the best interest of the corporation? So those are some things you might bring up to help them try to resolve those issues. And if you think this scenario is made up, I'd invite you to look at the Lee versus Silviera case, which actually, truth is certainly stranger than fiction. With it, if you've been doing this for a while, very early in the facts, you find out there's a 9-person person board, and you realize, like, okay, well, now I know why this is going to be a dysfunctional relationship, because it's just hard with that many people to get them all on the same page.
Can I jump in here real quick, Karen?
Of course.
So this,
I'm going to say no one time to see what happens.
yeah, I'll just turn it off and be quiet.
Survey says?
So you can see the nuances when that board, those minority board members call you and say, hey, we've got an issue here. And now, just the way that they characterize that issue could potentially trigger the 1.13F obligations, right? If they say to you, hey, we think we have a claim because there's a breach of fiduciary duty here. Well, just that is enough to say, all right, there's a potential conflict here. Now I need to tell you, I'm not your attorney. There is a potential conflict. This conversation is not privileged, and you ought to get your own counsel. Now, if the same board members start that call with, hey, we're on the board and we have concerns about this issue. It seems like a breach of fiduciary duty, and you're the HOA's counsel, so we need some advice on this. Well, are any of those same concerns implicated or not? Now, are they just a couple board members wanting to know if somebody is, what are their fiduciary obligations? What are the fiduciary obligations of the boards? And has there been an issue there? So it's unfortunately on our shoulders to make the distinction there. And I was just going to add one other thing. What is the consequence of failing to provide the necessary disclosures? Well, there's the bar complaint that could come down the road when those people do finally get another attorney. That attorney thinks about all the conversations you've had with their new client and your failure to make those disclosures. Or even worse, I was reading a case that Carson here referred me to where you could be DQ'd from the whole thing. Right? Motion to disqualify because you failed to because now the adverse party thought you were their attorney for halfway through their problem. So these are the issues, we have to be thinking about how these problems are brought to us.
Thanks, John. So let's change our scenario just a little bit. So we had initially a minority group of board members. Well, what if they woo one other person over to their side? Now they're the majority of the board. And they're unhappy with your advice, so they decide to fire you and bring in new counsel. And now you as the former counsel are like, wait a minute, they're doing all kinds of things wrong here. And you may feel like you want to tell the rest of the members of the community about the mistake that was being made by this new board. Can you do that? Well, let's look back at 1.13. Now, we talked a little bit about A. We didn't get to B in great detail, but take a look at B. And so as you look through these underlined sections, the first question here is, gosh, is the new board majority intending to violate a legal obligation of the association? Well, gosh, you're trying to break a binding contract. Well, that sounds like so far so good. Is it likely to result in substantial injury to the association? Yeah, it sounds like it could be. We talked about that. Then it's like, is it in the best interest of the corporation? Well, that's where it gets a little challenging to try to decide that, because the minority may very well think it's in the best interest of the organization, and that's somewhat of a subjective decision. And then look at this last part, which is extremely unhelpful to us. It says, the lawyer shall refer the matter to a higher authority in the organization. Well, who the heck is that? Is that the members? Well, maybe, I don't know. But it's a challenging situation. So the rule is there, but it doesn't really give you a whole lot of assistance.
So if you were at one of the attendants in one of the other presentations, they got into this a little bit, and Will's view was that the owners are the highest authority. So you go to whoever the officer is. If that doesn't work, you go to the board as a whole. If that doesn't work, then the owners, you need to communicate to the owners, was the opinion of another speaker who had done some work on this.
Sure, but there's one other consideration to think about, and that's 1.6 of the model rule. So the first part of it, we're all pretty familiar with. An attorney shall not reveal information relating to representation of the client unless the client gives informed consent. Okay, so far so good. Now B gives you a little bit of an out there. It says you may reveal information relating to representation under certain limited circumstances. And it's a pretty lengthy rule, but those limited circumstances are really very limited. They involve, if you're trying to prevent reasonably certain death or a substantial bodily injury, unfortunately it doesn't happen much in our line of work, to prevent the client from committing a crime or fraud, well, also not all that often. There's a provision that initially sounded helpful. It says to prevent, mitigate, or rectify substantial injury to the financial interest or property of another. It's like, oh, okay, that sounds promising. But then it says that is reasonably certain to result or has resulted from the client's commission of a crime or fraud. So B initially sounds hopeful, but it doesn't really help you that much. So now you're in a kind of an ethical quandary, and the question is, what do you do? Well, when in doubt, you might consider calling your ethics hotline. Many jurisdictions have a business judgment rule of sort for lawyers that gives you an out. If you consult with your ethical hotline and get advice from them, then it takes away your liability as an attorney. So that's a good thing to have. Even if that doesn't exist in your jurisdiction, it's a good idea to consult with them anyways, because now you have an objective third party, someone who's very knowledgeable about the ethical rules, who can give you options that maybe you hadn't thought about initially. If you also find yourself in this situation, you want to make sure you're talking to your law firm's attorney. You also want to talk to your malpractice carrier and make sure you put them on notice, because I'm pretty sure you've got facts and circumstances here that could give rise to a claim. So you want to make sure that kind of like everything you need to know in life you learn from the flight attendant, right? You flew out here and they said, in the unlikely event that we have a mid-air issue and our oxygen mask dropped from the ceiling, put your mask on and then put it on the parties that are traveling with you. Well, you got to make sure you're protecting yourself, not just your client in this situation. Okay. Another twist on this is, so the board minority remains minority. They don't woo somebody over to their side, but they go out and hire another attorney. And that attorney comes up with a second opinion. And there's some options here. There's some things you need to consider when that comes up. The first thing you want to consider is that not all second opinions are equal. Most of us, when we enter into looking at a situation, come in somewhat objectively. We know there's a problem. We look at the governing documents. We look at the law, civil code, and so forth. And then we try to come up with options and give the board some choices and help them make the best decision. Oftentimes, in a situation like this, when someone goes out to get a second opinion, they're not necessarily looking for an objective second opinion. They're like, hey, can we do this kind of thing, right? Also consider the source of who they're talking to. That I had a situation where we had a condominium community and a minor child of a tenant fell out of a second floor window and was severely injured. Initially, the HOA looked like it didn't have a whole lot of liability here because we didn't maintain the window, the owner did. We had no obligation to supervise the minor child of the tenant. But as you can imagine, the owner and the tenant's insurance was not adequate for the anticipated damages. And so the HOA's insurance carrier entered into a settlement agreement. They didn't pay the policy limits, but they paid a pretty substantial amount of money. And so a couple of months later, HOA goes to try to renew its policy and gets denied. And they go shop around. They ultimately do find coverage, but their premium has gone up like 4 or 5%. They have to do a special assessment in order to cover the cost of the increased in insurance premiums. So there was a board member who said, well, gosh, there's this CC&R provision that says if an owner does or does not do something that results in us having our insurance dropped or having our premiums rise, we have the ability to go after that owner for the delta. And so you can all think of like a dozen reasons why this is really a bad idea, right? So we laid out this lengthy opinion letter to him, and we sat down and talked with him. But of course, this guy worked for the city of San Diego. And he went and he talked to his friend, and his friend, now he works in the environmental division. So like if you know anything about water and storm drain issues and that kind of stuff, he's probably spot on that. Knows nothing about our area of law, but he's like, oh, it's a no-brainer. Not only should the HOA sue the owner, they should sue the tenant for failing to supervise their kid. So be careful what the second opinion is and what the source of it is. A good practice is try to make sure you get it in writing, so you can see the basis behind where the opinion comes from and get authority from your client to sit down and review it at length, and then sit down and talk with your client about this. But also don't have blinders on. It's certainly not impossible that you might be in a position where they actually have some good ideas. I mean, many of us work with law firms or ourselves have done constructive defect litigation. It's not uncommon at the conclusion of those lawsuits that the end result, when you go forward to do the reconstruction, it kind of commingles some things from your side, the plaintiff's expert, but also some ideas that came up from the developer's side too. The ultimate goal is you're looking for the best result for the association. So don't get so single-minded in your focus that you forget that there might be some other good points out there. Okay, we talked about the casual second opinion, and we also talked about not being too proud to take some good things from there. What are some things you can do to prevent this from happening? If you look at the ABA's website, one of their studies concluded that confusion about complex issues and poor communication between the attorney and the client is what often results in them going out and getting a second opinion. And so if you start getting the feeling that your clients are feeling a little bit overwhelmed by the complexity of the issues there, maybe it's a good time for you to have a meeting with them, sit down and talk to them about the issues and help them understand things. And that may prevent, pardon me, I'm getting a little wild here, prevent them from going out and getting a second opinion. So that's a good thing to consider. It's interesting, though, too, if you read on the ABA's website, that from their perspective anyways, they equate a legal second opinion to a medical second opinion. They talk about all the virtues of it, and hey, there's no shame or harm in it. They make it sound like it's the best thing in the world. Your opinion may vary there, but that's the company line from the American Bar Association. Okay, one last ethical rule to end our Saturday session. Okay, part of you may be saying, well, wait a minute. How did this minority group of board members go out and talk to another attorney? The other attorney, 3 minutes into it, when they start talking about the issue, realizes that the association is represented by counsel. Isn't that other attorney ethically prohibited from talking to them at that point? Well, the answer is no. Model Rule 4.2 has a comment section, and comment 4 says, nor does this rule preclude communication with a represented party who is seeking advice from a lawyer who is not otherwise representing a client in the matter. So the minority group was able to go out and talk to an independent attorney about their issue without that attorney being an ethical quandary there. So just something to consider, that I was initially thinking that would be a great out, but sadly, no. We can't report the other attorney who issued the second opinion to the Bar Association, much as we might like to do so. Well, that concludes my portion of the presentation. We have a few minutes left for some questions if anyone has any questions. Sir, I don't know anything about righteous snow, so I'm going to defer to John if we're going back there. Sure.
We've been talking about situations in which ethical issues arise often because one constituent is claiming that another constituent has violated or breached its duty of care or fiduciary duty to the association. Frequently, though, in my experience, what you end up with is several board members trying to get you to sign on to the proposition that the association is required by somebody's fiduciary duty to do it my way, and if they do it the other way, it's a breach of fiduciary duty. And it may not be really a question of absolute duty at all. I've said to boards sometimes, there are decisions, there are choices that have to be made. That's why the law requires a board and not just a lawyer. But how do you deal with those kinds of situations? I've said how I do. But how can one deal with them without ignoring the possibility of breaches, but recognizing that you're counseling basically a political activity rather than a judicial inquiry?
Sure. Well, one thing you could do is look at both propositions and say, well, here's the pros and cons of doing what Smith wants to do. Here's the pros and cons of what Jones wants to do. And ultimately, the decision really is going to boil down to what the board majority wants to do. But you've given both parties an opportunity to make their case, and hopefully that may help resolve the situation. If they're truly that divergent in their opinions, well, sometimes one of the downsides of democracy is you don't always win, right? So if the minority board member can't live with the fact that the majority didn't like their position, well, if you can't wholeheartedly endorse it and go forward and implement it, maybe they should resign from the board. Now, that's not great advice to give. They're not going to like it, but hopefully that by listening to them, giving them opportunity to make their piece, by helping out, researching the pros and cons of sides, you might make them feel like they were heard, and they will take defeat a little less gracefully. But that's not always going to be the case.
I would just add to Kieran's comments kind of the same thing. What I try to do is clearly distinguish for the board between legal issues and political issues, and just make sure they understand, hey, this isn't a legal issue. This isn't, you're well within your fiduciary obligations to make either decision. You just need to vote and move on, and just like Kieran said, accept that sometimes it's not going to go your way.
There's a lot of issues that aren't black and white, sadly, in all areas of law, but certainly in ours. And the word reasonable put more kids, lawyers' kids through college than probably any other word in the English language, right? Thank God, But so there's a hand in the back, sir.
Sorry, they want to record everything.
Bad board.
You could just drop the word bad, I think. We all know what we're talking about.
Bad board receives a petition signed by the requisite number of owners to call for a special meeting to remove them. The board ignores the petition. The petitioners have a statutory right, and they do hold a special meeting, and they are successful in the vote to remove the board. The bad board says, H, no, we're not going anywhere. The good people who you think are going to be much better board members then come to you and say, what can we do as the new official board to force them to accept the results, turn over the bank accounts, get out of the way so we can move forward.
So I guess in your scenario that you didn't represent the association until after the recall occurs and the new board is elected.
No, we did represent them before, acknowledging several times, board, you're making poor decisions.
So he said that they actually had represented the association the entire time, and they counseled the board throughout that they were making bad decisions. I know how this would occur in the California Corporations Code, much like in your jurisdiction, that there's a finite period of time after the recall notice is received for the HOA to set the recall meeting, 20 days. And if they don't, then the other party has the right to set the meeting. And so starting at that point, once the recall petition is received, that's when you start trying to educate the bad board, if you will, about what their obligations are, and say, hey, you may not like it, but this is their right to do it. You can look at the signatures and try to determine whether there's 5% or not, or whether husbands and wives or tenants or people, maybe that knocks some of them out. But if they ultimately have reached that 5% threshold, which candidly is not that hard to do sometimes, and they proceed with it, I think you got to start educating that board early that this is a potential outcome, and if they want to be different, they better go out and start campaigning and get their friends and neighbors who support them to come out and vote for them in the recall. But if ultimately you're unsuccessful and the new board has been elected, well, you represent the association, and the association is governed by the duly elected board, which is not the bad board. It's the new board at that point. And so that your client really is it's no longer, the bad board doesn't really have a voice in this. In most contexts that I deal with, I guess in smaller associations where they may be self-managed, or if they have an on-site manager in some of the larger contexts, then usually there's a management company involved here, and the management company helps you dealing with the transition of records and bank accounts and so forth. So I've not actually had this scenario you were talking about where the bad board is refusing to turn over records, but ultimately you have a lot of authority and law in your favor to compel them to do that. Hopefully it doesn't come to that. What happened in your scenario?
My scenario hasn't actually come to fruition yet, but in terms of the management company, the bad board fired the prior management company because they were telling the bad board the same things that we were, like, you have to call this meeting, you have to recognize the validity of the vote, and the board said, look, all those statutes apply to big corporations. They don't apply to our little condominium.
If only that were true.
To add some perspective here, so I haven't had that exact scenario, but we've probably been through a dozen. We call them the coup, where a group of owners or whatever decide to throw out the old board, and we've represented owners, helped them do that, and also been on the board side. On the sides that we've been on the board side, we haven't had a board yet refuse to go through the process. But I would just offer this advice in dealing with that. That process of, calling a meeting, giving proper notice, proper signatures, actually conducting a meeting, having a proper election, and removing a board is fraught with problems. In my experience, half the time the notice is improper. I've reviewed those notices for boards before. Hey, we got this notice. They want a new meeting. They want to have a meeting and throw out some board members. Half of the time it's just wrong. They haven't complied with the CC&Rs or the statute or whatever, and then you can't acknowledge it, right? You just have to tell them, no, you've done it wrong. We're not going to call a meeting, and that's how it's going to be, because you're damned if you do and you're damned if you don't. If you go forward on a faulty notice, well, then the other side will challenge that. So just a little practice pointer when you're in that situation, be really, really careful about picking sides until you're very sure that the procedure was proper, because it's frequently screwed up.
One other thing you might think about, if you think back to what we talked about with the business judgment rule and the fiduciary duty issue, the price of poker has gone up, right, for these bad board members. They're no longer duly elected board members covered by the directors and officers insurance. They're not on the hook personally for themselves. Like if you end up filing an injunction action against them, that they've got to hire their own lawyer. If they lose, they're on the hook for their own damages. They may start to lose some enthusiasm when they realize they got to reach into their wallets and deal with this here. So letting them know the consequences of staying that course of action may be a way to help resolve it. But otherwise, you may end up filing suit. But the new board, as long as you filed, what John made a good point. As long as you make sure that they followed the corporate requirements and they were duly elected under the old board was recalled and the new board was elected, well, that's your client, and they speak for them, and you got a lot of authority there. Anyone else? Well, thank you for getting up early on a Saturday morning getaway day and coming in and spending some time with us. We appreciate it. And everyone have a safe trip home.